Aye.
Mr. Blumenthal.
Aye.
Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Ms. Butler.
Aye.
Mr. Graham.
No by proxy.
Mr. Grassley.
No by proxy.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No.
Mr. Hawley.
No.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No by proxy.
Mr. Tillis.
No by proxy.
Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Next is Nicole Berner, nominated to the Fourth Circuit. Does anyone seek recognition?
Mr. Chairman, I seek recognition.
Senator Lee will be recognized first. Senator?
Thanks so much, Mr. Chairman. I've got some concerns with this nominee who's been nominated to serve on the U.S. Court of Appeals for the Fourth Circuit. Among other things, she spoke on the topic of economic justice at Rutgers University. And while delivering those remarks, she compared the Republicans serving on this committee in reference to the confirmation proceedings of Justice Kavanaugh to union busters. And it's an interesting comparison, not terribly eyebrow-raising in and of itself, other than what you look at what she actually said, and her reasoning makes no sense. Certainly not the kind of sense one should come to expect from a life-tenured federal appellate court judge. She said, quote, despite the fact that multiple women have incredibly accused Kavanaugh of having sexually assaulted them, Senate Republicans allowed only one woman to come forward to testify. They ignored or belittled the other accusers. The fact that Dr. Ford was the only person allowed by Republicans to pretend the situation was she said, she said. These techniques were taken directly from the playbook of anti-union employers during union organizing campaigns. And yet, in sharp contrast to that assessment, which is wrong in many, many ways, didn't really hold herself to the same standard. Her own handling of an SEIU complaint involving a sexual harassment scandal demonstrated that she sometimes does think women who accuse men with authority over them in cases involving sexual harassment perhaps should be ignored. At least that's how she proceeded. She failed to disclose to this committee her involvement in the sexual harassment problems, prominent problems within SEIU. And second, her actions in that particular case, as detailed in an expose published by a pro-labor website, the Payday Report, appear to show that she declined to meaningfully investigate multiple serious allegations of sexual harassment by SEIU officers and affiliates. She declined, despite the obligation to do so, to disclose her candidacy in the 2020 World Zionist Congress elections, despite the fact that it was clear she was required to do so. She failed to disclose a 2020 letter taking some strident positions regarding Israel and its approach toward Judea and Samaria, even though she was required to disclose that. She holds some pretty radical union labor-focused views, including promoting policies that would make it illegal for an employer to inquire about a worker's immigration status during an organizing campaign, requiring prisoners who work in prison to be entitled to labor law protections, including minimum wage. She promotes policies of workplace councils, which would require 40% of corporate board seats to be controlled by workers, and requiring a supermajority of board members to make corporate decisions that directly affect workers, such as decisions to declare bankruptcy, close a plant, lay off a significant number of workers, and so forth. And she said, quote, at its core, the right to work movement is deeply racist. Interesting and indefensible. She opposed the planned Catholic community of Ave Maria in Florida because, as a staff attorney at Planned Parenthood put it at the time, she determined that the community would favor a pharmacy that would not sell birth control and banning one that sold contraceptives altogether. That's a quote. Her name appeared on an SEIU brief in Reproductive Health Services of Planned Parenthood of the St. Louis region versus Parson. The case concerned whether Missouri's prohibition of abortions performed solely because of Down syndrome, solely because the baby being aborted had Down syndrome, was per se valid. You couldn't protect a baby with Down syndrome on the basis of it having Down syndrome. She even went so far as to argue that such protections for babies with Down syndrome would be patently unconstitutional. And she has said that Margaret Sanger, the infamous eugenicist founder of Planned Parenthood, is one of her childhood heroes. These statements concern me, and they don't reflect the careful, reasoned judgment of someone with whom we should be entrusting a life-tenured position as an appellate court judge. Thank you.